It is too high. Take this one to the one is it?
I firstly a complaint to the court before asking what is the issue for the day. As we were coming in, a certain police lady by the name of Asio was hostile and rude to me, telling me that this is not a Kenyan matter. we do not come here to be disrespected. We come here to do our duty as officers of the court. And this is not the first time we are making a complaint of undue hostility. My officers manning the gate, but today it's specific on the police officer, a lady by the name of Asio. And it is the duty of the court to protect me and other court officers from undue harassment. We are here to do our duty under the Constitution and the laws of Uganda. And I'm duly licensed to practice here for this case. We are urging the court to discharge its duty of ensuring that we come in here without let or hindrance. And that the officers know their boundaries when manning the court gates.
That police officer is here or is at the gate?
I think she is at the gate. Yeah. But as I've stated, I did also report to her superior, Mr. Chebet, who was not at the gate at that time.
What will handle this incident with you and the senior, the one you said who was at the
Chebet.
gate? Chebet? Come here.
I'll leave the matter to the court.
Okay.
Having said that, I left the court before the last orders, but I'm told that we are here for case conferencing and direction on the hearing. But from the defense, we are yet to receive all the documents and evidence relating to this case. We have a huge file that has 4 witness statements and tens of copies of transcripts.
Otherwise, you are saying they have disclosed.
No, I am saying we have 10 witness statements handwritten, not 10, 4.
Oh, the
4
prosecution.
from the prosecution, and tens of pages, meaning 20, 30, 50 of transcript from audios or videos we are yet to receive copies of. So we wouldn't know whether those, from whom those transcripts are. We wouldn't know the voices in those transcripts. I have had a conversation with Mr. Dentiko. I think he can reach the court or confirm to the court that indeed they are yet to fully disclose the case our clients are facing. And as such, we feel we should not be going into conferencing when our clients have not been given adequate time and facility, because that means disclosure, time and facility for the case.
And for the record, I'm Thomas, so assistant deputy. As rightly put by my land senior assistant, we gave the defense transcribed material of audios. We gave the prosecution some defense transcribed material from audios and videos together with witness statements. I wrote from the moment that we received the transcribed transcribed material and the original gadgets from which these were transcribed from, we have been in the process of having this material transferred to gadgets, various gadgets, which can enable us ably disclose to them. Some of these include flash disks. And my lord, today I believe there are 18 lawyers here, and so we are really trying to make sure we have copies for all of them. And this will be accompanied by the forensic report. I know the prosecution is confident that if given a date by Tuesday next week, we would have served the defense. We would have done it maybe by Friday over the weekend, but my Lord, to be on the safe side, we pray for to make this disclosure by the Tuesday of next week. That is that. Of March. I know that is the position of the prosecution.
It's not that clear as to the prayer you're making. The prayer you're making is not clear. We have not had any application for an adjournment of the matter. My learned friend, Mr. Judge, simply indicated that it will be ready to make full disclosure by that, leaving court in suspense. That's what we done with the schedule of today, which is conferencing. If my Lord, I understand him to be making an application for adjournment, third or thereafter, we strongly object to that.
Can we get a clarification on the people? As far as what is saying today, before you go for adjournment this week, what we scheduling today? Let me call it the preliminary hearing and schedule it as let us, so before you go for
That has included the disclosure. And I was polite enough to be responding to the immediate query of my land sister. And my Lord, that instance, the prosecution will be praying for an adjournment.
this clarification.
My Lord,
Let us do this narrow down. Most of you were saying it is part of the story, which have been done. Did I think most of you?
yes, my Lord.
So, you have partially disclosed.
Partially disclosed. And my Lord, the prosecution did not wait to reach scheduling today, because that is when we would be agreeing on disclosure. We started this knowing that we would have time within which we would need to transfer this material from the gadgets to a disclosable mode for all the defense counsel that are present here. And So we did not wait for today to start this schedule, my lord.
So you are saying you disclose it partially before today?
Yes.
You're supposed to do that.
Yes, my lord.
And then you say full disclosure by next week.
Tuesday we shall have given them disclosure, my lord.
So you are proposing that if I put it.
My lord, if you could visit the record,
Just
the proceedings of 30th of December.
what I'm saying.
Yes. Yes.
I want to start with you and Council Master. Disclosure was partially done. It's not in it.
No, my lord, wanted to address you mind to the order of this honorable
Go
court.
to the order. Let us go to disclosure.
Yeah, the order regarding disclosure, my lord.
Yes, it was partly done,
My lord,
and they
before,
have not fully disclosed.
before we come to partial disclosure, we wanted to,
Council Park. The issue here is disclosure.
yes, my lord, and there is a
They are
court
saying
order to
they
that effect.
partly disclosed.
And there is a court order to,
Let me know your response of disclosing fully if I go from the prosecution. They disclosed partially, which is not the prosecution. But now we are saying they are praying that January full disclosure by next week Saturday. So let me get your response.
okay. Our contention, my lord, is that partial disclosure was done in violation of a court order. Because my lord, on record, specifically the proceedings of 30th December,
You are saying they violated by disclosing before today.
no, by making partial disclosure. Full disclosure ought to have been done by 21st January 2026, as per the court order of record of 30th December 2025. There was a court order directive that they should make full disclosure by 21st January. The reason as to why that was not complied with is not satisfactory. If I listened well to Mr. Jatiko here, that they are still doing it, they have not completed the transcription. I will just that but you are talking of gadgets. The gadgets containing that particular evidence which they wanted to transcribe being somewhere, kept somewhere. That's how that's what I have. That's what I have. Otherwise, my lord, the transcription should have been accompanied by the flash disks he's talking about, the video recordings, the audio recordings should have come with a transcribed record, which is not the case. Second, my lord, when you look at this file here, which they served on us, it indicates volume 1. So we have no idea as to how many volumes they are processing. We have no idea. Volume 1, is there volume 2, volume 3, volume 4, volume 5? The order was specific. By 21st January, we should be in possession of all what they are talking about. Whether they are several volumes, they should be with us as of 21st January. So court orders are not made in a vain, my lord. That very day on 22nd, 21st when we are here, my lord. The last time we appeared here on 21st. There are orders that were given to serve us within specific timelines, and they never comply. My lord, if I may revisit the proceedings of the day, we indicated to court on that day, 21st, that the TIA provides for a notice of 14 days. 14 days before one takes a plea. And in the ruling of court, my lord, in the wisdom of court, that notice with all due respect to God, was superfluous. So court went ahead to direct that everything be done on that day, 21st. And disclosure be made so that we come here for conferencing it today. Now we are getting the shock of our life that we are not ready to make a full disclosure. That shouldn't be condoned in our court. My lord, why we are raising this matter? I want to conclude. Why we are raising this matter? We have been unfair accused as the prosecution, the defense lawyers, for delaying the hearing of this matter. We have been unfair attacked. As we state that we are deliberately delaying the proceedings of this matter. Now here we are. That is one of the reasons why we take exception with the conduct of the state in this particular matter by making impartial disclosure. The second reason is in regards to the health of our client, particularly A1. So any delay occasioned by inadvertence on the part of the prosecution aggravates the matter. So A1 is not doing well helpful and he has not been granted bail. So my lord, we pray that this court takes cognizance of that conduct first and foremost, and then one way or the other issues some directives to the prosecution here in regards to that particular conduct, where they defy court orders, make a partial disclosure as opposed to full disclosure in total disregard of the court order that was made.
I know this court has a record of the scenarios that my learned friend going through, and I also do have a record. So my be the court record. But my lord, this matter came to court on the 30th December. And my lord, 30th December 2025. And my lord, among the things that the court had said, assessors shall be appointed with full details at the time of hearing, and among others, the court directed that the matter is fixed for scheduling on the 21st of January 2025 at 11 a.m. Matter is fixed for scheduling for the 21st of January 2025 at 11 a.m. And there were no directives as to disclosure from this court. However, my lord, the prosecution insisted that it will make partial disclosure. The prosecution said it will make partial disclosure because all these matters are supposed to come for scheduling on 21st. In fact, we did make this partial disclosure as confirmed by the defense. My lord, on 21st of January 2026, the accused persons never appeared in court. On 21st of January. And my lord, we were in court, and they said the accused person and all persons is or are unaware. And my lord, a fair hearing also calls for the presence of the accused persons really these matters in court. And we are all in court if counsel, my lord, senior colleague in court. We felt their plight and the plight of the accused person. And my lord, the matter was adjourned today. And we have humbly told this court that the materials that my land sister, she has talked of tones. My lord, that information must be transferred in a form that we can give them. Today there are about 18 lawyers. It's not a piece of cake, my lord, that we are sharing out. This, we must maintain integrity of this evidence that is coming before. And my lord, to say that we were in violation of the court order, my lord, we believe is misleading this court. And we retaliate that the prosecution shall by the 3rd of March 2026 give disclosure to the defense in the form that they can be able to look at and be able to advise themselves about the case. And Lord, we believe this is the true position of this court. And this court has the privilege to visiting even the record. If I am not wrong. So humbly pray, my Lord.
When you simply talk about the time of disclosure as a state, you are failing. You need also ask for when you are ready to do the scheduling, because we are here for scheduling. You disclose on Tuesday. Tell us when we will, or give us an indication so that we also tell you when we will be ready for scheduling. Because for the record, Your Lordship, we want to emphasize that and to clarify that it's impossible to schedule without full disclosure. The reason the state must shoulder the burden and accept that they are the reason why we have not scheduled and why we have not proceeded to trial is because they have hitherto failed to fully disclose. Had they disclosed, we wouldn't be having this discussion. Today, we probably have scheduled. So we need full disclosure in a time sufficient to allow us to peruse it, and then prepare to schedule, and then at schedule, lay out the roadmap for trial. The state should stop delaying, procrastinating diary and then coming here and later in the public domain lambasting the defense team for their own claims of a snail-based and lackadaisical approach towards the prosecution of this matter. We reject it, and we think you should join us in treating this prosecutorial misconduct to the point it deserves. The issues of sickness are red herrings and are diversionary. They have nothing to do with the disclosure. Have the defense, the prosecution failed to disclose because the grants were sick. So they shouldn't take us there. Let us focus on their duty to give us every document and witness statement in their position so that we read it, we come here and check it, then we go for trial. So can we hear from the prosecution when they are ready for shaping?
Just clarify this. Because we wanted the record to be consistent. Before we look at the next course of action, the record of 30, because we have a position, 30th of December, we have a position that there was a directive that this closure should be done by 21st January, and that schedule will be done on 21st January. Mr. Jatiko is saying, no, there was no directive to that effect. This must be sorted, my lord, before we proceed. Was there a court order to that effect that there must be full disclosure by 21st January? Given handed down by this honorable court on 30th of December, we insisted that is the position on record, my lord, and they never complied. And why we are justified in our submission, my lord, in our line of contention, my lord, is very clear. And actually, it's logical. There was no way we would come for scheduling on 21st January before full disclosure is done. It is simply a matter of logic that we were supposed to come here for scheduling on 21st January after full disclosure is done. Now, Mr. Jatiko is insisting that the position of the prosecution is that by 21st January they will do partial disclosure. Whether anyone was indisposed or not on that day, it's immaterial. There was a standing order of this honorable court. And this is the matter we are seeking to be resolved first before we focus on anything subsequent to that. We do so for my lord.
I want to put on the table full disclosures item number 1. Who can read for me section 67, 1 and 2? I'm going to vote that. Section of PIT 67, 1 and 2. Can you read it for me? 67,
Preliminary
1.
hearing.
Yes, the title is?
Preliminary hearing, the title. That's 67, subsection 1. Notwithstanding section 66, if an accused person is legally represented, pleads not guilty, the court shall, as soon as is convenient, hold a preliminary hearing in open court in the presence of the accused and his or her advocate and of the advocate for the prosecution to consider such matters as will promote a fair and expeditious trial.
Yeah, 2.
67-1. 67-2. At the conclusion of a preliminary hearing held under this section, the court shall prepare a memorandum of the matters agreed, and the memorandum shall be read over and explained to the accused in a language that he or she understands, signed by the accused and by his or her advocate and by the advocate of the prosecution, and then filed.
So I just want to know, let us now put full project on the table. The long handle, apart from that, apart from food, disclosure can be first itemized other things before I pronounce myself.
The problem is the guidance one.
The guidance I want to
The itemization you have would tantamount delving into the schedule. That's what happens at the schedule.
I have got to correct the things. We are very carefully listening to the submission because it's the same as the good. But briefly, the issue is full disclosure. I have heard that the Constitution has so far made partial disclosure, save Council Quantum, who said that even it was done by violating the regulations of the sport. But I will now go ahead and make the following observations. That for the interest of justice, and by the nature of this case, I directed that the Constitution from now to start should have made full disclosure, bringing them from now to start full disclosure. And then we come back here for final scheduling or preliminary hearing on SAD to tackle other issues that we shall have agreed upon after full disclosure. So we shall come back here on SAD March at 11 for further scheduling after full disclosure.
My Lord, seek to have time with our clients before they're taken up. At least 40 minutes.
Just know that we should just highlight the form of disclosure because ideally we should come up for scheduling after they've done the disclosure and we have considered what has been disclosed with our plan. Yes, my Lord, if I just show out volume 1 of the disclosure exists, and my Lord, they said it was the first volume. When we spoke with our colleagues, they said that they had 3 batches. But it's unlikely because when I was reading in preparation,
What I was saying,
yes,
my Lord, is that we have agreed on one items.
it's about the title.
One. We have said item 1. We need to know whether they have money.
Yes, my Lord, because if they disclose even half of this, I retired when I had read up to page 773. It's unlikely that if they conclude on the fact, we shall have made copies, compare them to the client, start with them to go over this, watch the videos, listen to the audios on that day.
So what are we suggesting?
So the challenge, my Lord, is that if they can indicate the volume of material they
We are going to
have,
serve you from this side.
yes, so that, and then we shall also ask to be facilitated to have the accused people access this with us in a matter which allows the necessary confidentiality to go over these documents and then the investigation. The unfortunate event is that they are in confinement. It would have been a lot easier if they were now like
really my mind. That's what I was saying. All along, that's what I was saying. That before even I give a directive now, finally. So you have itemized that and you have told us. That's what. But still, for the interest of the state, can state probably. Do you have an idea from now to this part you intend to submit? So, because if I have come to council, but they were saying, sir, if they serve you with more volumes, still on the side when you look too much.
If I may be of question. Thomas, San DPG. The order is that we should serve the defense by third.
Yes.
I know that includes up to close of business on third. My Lord,
No, I said, no, it can't be the end. Because we are saying here we are coming back on Saturday at heavy.
but I will still have close of, I could serve them at 4 p.m. on third.
What I'm suggesting
My Lord,
is a
pray that the date for coming back to court be pushed to
not on Saturday.
not on that. Because they will need, because we have so many videos, so many audios, and if by third I have served them, they will not have looked at all those things to be able to give. I'm not the defense counsel, but I believe that is what they are trying.
It's like now we are what I was supposing to make. So council panel. Now, you are saying from now to start, indeed if you are serving with many volumes by side you look up. Now council Jatiko is saying I'm doing this group in this. So can we have these when we come here? But full disclosure is we have a big line. So what are you suggesting?
I know the inquiry points to the volume remaining being bigger than this. So we can return, and that is the exclusive of the video. The documents are bigger than this, then there are the videos and the audios. So we request that when you come back after a month, update court. Why so, my Lord? Because the disclosure may have been made on the third, and we have not gotten an opportunity in the right environment to confer with our clients regarding the content. Because there are two things. The copies have to be made, be sent to the prison authorities, they have to check them. We have to have facilities to watch the videos with them. So he requests that after a month, we come back to update court.
That is sad to take us to the course of March. Pointed out the issue of blame and that we have been attributed to the defense that now the prosecution issue of blame. Then too, that one of the accused persons. So don't you think the more we keep hearing months and months and months?
Hey.
Yes.
Is the solution to seeking it? I had to watch coming. Because my look, I'm thinking the first one is very difficult. Very difficult. So maybe we consider the second one. God gives us a solution. We are ready. There you go.
Because even when the disclosure has been done,
Yes.
okay, when the disclosure is complete, each one of the accused persons, because they are jointly accused, has got to have an opportunity on their own to read all the materials. So the discussions with them can be at fact. Now, whether at the prison, if they are given a batch of 2,000 pages, they can afford to read 300 in a day. We don't, because every material that is taken has to be seen. There are videos to be watched, so, and the practical thing, of course, is to consider this in a place which is not the prison. But my Lord, that is the challenge, because we don't want to come third and then we take the receipt, now we have to translate.
Hopefully for now. Yes. Like what you are saying, still it goes after you say, for instance, if we are saying item 1 for this board, I have already made the directive. Is such much. Now item number 2 would have been how long are you need the defense? How long does the defense need to read this book? Item number 3 is what we're talking about. What about contesting? Item number 4, we go to, I will find out whether you have agreed on the facts, whether you have agreed on some of those people who are talking about. You have expected that you have agreed on some facts, you have agreed on some documents. Now, finally, today, we have finished. When are we coming? So those are the items that we say that for the interest of justice. But now, they say one of the, another point was if the president said whether he's able to stand the trial. So these are the things where we have advised for the interest of justice. But I don't know,
My Lord,
probably didn't understand.
My Lord, I hear you. The challenge is, I call it
Time
time.
frames and what
The challenge which we have is that we'll only be able to say that we can read these documents through these weeks. If we have,
if you have not finished, you come back here. And if, for instance, you come and say, we have passed the subjects with volume 1, but now we have volume 1 to 10. We couldn't have finished them in this week. Then really we have a mess. I think if you,
so it comes back to what was said. It is now the stage to be sure to say we have 2,000 pages left. Then Mr. Lukwabo will say, I can read 2,000 in 2 days.
let me do this now.
And what my Lord also, from what has been disclosed,
I have captured that now it is practically possible. But for the full disclosure, we have agreed by SAC, isn't it?
because from what has been disclosed before, my Lord, what has been disclosed, some of the documents are incomplete.
That's completely different. 6 would have maybe expired. Then from SAD, so senior council team, we get that full disclosure, go through it, and then we come back here for final scheduling on 12th March at 11. So let us do that and follow the board's directions. Then as I take leave, prisoners, you can allow some muscles. Prisoners, I just wanted to say, allow them to talk to their friends. Then finally, the either cast or partner, if you have time and I wanted us to discuss this issue of security. We can have nearly four children, say 4 people. Then we come to my check. Then we the senior police officer and we discuss that. I want to request the Yatipa and just to give us a minute for the story of you and then the story of you. Yes, I see what I still discuss.
This is not prosecution. It is persecution. At every turn, you see a biased judge trying very hard to drive through a case, through illegalities. Like now, he was trying to say, go and schedule, make a program for the hearings without them having the full information of what they have to defend about. And it took us more than an hour with him fighting on the side of the prosecution to drag the matter, make a trial plan without them having what he's basically accused of. He is so unjust. He does not hide. We do not have here a fair trial. It's not a fair trial, but I'm proud of the legal team. They are fighting hard. They are holding him accountable, and he's showing himself to the world that he's here to execute the command of his master, General Museveni, not deliver justice. You know what? We've come round and we have exposed them. Yesterday you saw for yourselves. General Museveni has given himself the power to decide that I can't pray for my husband in my church, the Catholic Church, by my own bishop to pray for my husband. He has given himself the power to stop us through the church, our church, to stop us praying. Now, what else do you want? General Museveni and his son have decided they control our lives completely, including our spiritual lives. Well, let me tell them this. They will never control our spiritual lives. And the Catholic Church stands strong. I'm very proud of our Archbishop Paul Semogerere. He stood up to him. When President Museveni rang him, he was telling him to cancel. And Archbishop told him, President Museveni, this will backfire on you. You should not enter the space of the church to dictate who is prayed for and when. And at that point, President Museveni took a step back and said, okay, just postpone for a few days. I will come back to you to tell you because I want to investigate that mass. Who investigates mass? Mass was there. You saw the order of mass. It has a procedure. It is sacred liturgy. And what has he got to investigate about that? But look, our Archbishop is waiting for him. On Friday, he said he would call him and he should tell him what he has found in his investigations. I'm also not giving up. This is my faith. I am baptized in this church. I was married there, and I want to pray there. And for President Museveni to think he can stop me praying for my husband, he can go there and tell lies and hang him. But he can't stop me praying in my church for my husband. That's what I am going to take him on.
Does that continue the
status of your husband? He's not well. He's weakening. This man is going to be 70 years old. In April, he will turn 70. This whole year in prison, he has been suffering conditions of jail that are harsh. Slowly his health is deteriorating, and General Mozi keeps threatening and saying he's a dead man walking. I will kill him. So their intentions are clear. It is to kill him. Keeping him in prison, denying him bail is part of that intention to kill him. But you know what? It is God who gives life. It's God who takes it away. We will all die one day. You're welcome.
Okay, as you have noticed today, our first complaint was the difficulties we face in accessing the court premises. Today, I was harassed as I was entering the court. There was a police officer by the name of Asio. She wanted me to alight from the vehicle outside the gate. And I refused, telling her that all the times I have come here, my vehicle is allowed to drop me on the staircase next to the court where I was going. So she allowed the car to enter the court premises, and next to the door, she now came again and told me, "You are now inside the court premises, get out." I told her no, I wouldn't get out. I want to be dropped where I'm usually dropped, next to the court, not at the door of the court premises. And she just from nowhere said, "Why are you being difficult? This is not a Kenyan matter. I have not come to Uganda or to the court to have words thrown at me and disrespect shown by a police officer or anybody else for that matter. When I come to court, I come as an officer of the court, duly licensed under the laws of Uganda. And that is why I raised the matter with the court. The court has a duty to protect all those who come to the court, both those who come to listen, the accused persons, or people like us who are officers of the court. Because how else will an accused person be able to have a lawyer of choice if when we come to court we are subject of harassment? The court has promised to deal with the matter, and we will be approaching the judge in chambers as he asked us to do. It's just that we had to first see our clients in the court cells before they were taken to Luzira prison. Now, on what has transpired pertaining to the case, today was what we call case conferencing or scheduling for the court to say when the hearing will start and how long it will take. All those things are pertaining to hearing. We told the court we couldn't go there because we couldn't start with the case conferencing because the prosecution only did a partial disclosure. They've given us statements of 4 witnesses and transcripts from audios and videos that we are yet to see. The Constitution of Uganda is very clear that there should never be trial by ambush. An accused person and their lawyers must have in advance the evidence against them, all witness statements. If there is a transcript, you give the audio first, long before the transcript. How do we know that the transcript is the same as the audio or that it is authentic? We also have a duty in these days of AI to know whether the transcript is actually a real transcript or a fraudulent one. So on that basis, the court has adjourned the case to the 24th of March, to the 12th of March, and the prosecution has been ordered to give us full disclosure on or before the 3rd of Now, the prosecution has been claiming, we've seen it and we've seen government officials, including officials from State House, especially during the campaign period, claiming that it is the defense lawyers who are delaying the case. We want Ugandans and the world to know that up to now, the prosecution has not done full disclosure. Under Ugandan law, the case cannot commence without full disclosure. So the delay in starting Dr. Besigye and Obed Lutare's case is not on the defense, it is on the prosecution. We also worry about Dr. Besigye's health. Anybody can see for himself that he looks frail. He's getting sick so often in prison. We do not know what has changed in that environment, but it's certainly compromising his health. So I was telling the court, I was pointing out to the court that the health of Dr. Besigye is among the things he must consider. Because at the end of the day, the court will want to know whether he is in a position to go on with the trial as he is. I think that is all that has gone on today.
Mulabye ebibaddewo olwaleero mulabye ebibaddewo olwaleero nti omusango tegusobodde kugenda mu maaso olw'ensonga nti abawaabi ba gavumenti balaze nti bo tebannaba kweteekateeka kimala okutuwa obujulizi bwe bagenda okuleeta mu kooti. Mukimanyi bulungi ng'ennaku z'omwezi 3 omwezi ogwa December omwaka oguwedde era tukijjeyo wano mu kooti kooti yabalagira nti obutasukka nga 21 January bateekeddwa okuba nga batuwadde buli kyonna kye bagenda okukozesa ng'obujulizi. Baatuwaayo ka fayiro kamu kalimu statements 4, kalimu ne zibayita transcriptions oba ebiwandiiko bye balaga nti bavundula babijja ku butambi obwa vidiyo n'obutambi obwa audio obuwulirizibwa obuwulirizibwa, naye tebaatuwa butambi bwonna bwe bateekateeka okuleeta. Aga amaloboozi ge bagamba ge bateeka mu biwandiiko gali ku butambi. Obutambi obwo tebaabutuwa ate nga ssemateeka akirambika bulungi mu nnyingo eya 28 nti byonna by'ogenda okuleeta ku bujulizi ng'owozesa omuntu olina okubimuwa ng'okuwozesebwa tekunnaba kutandika. Baabagamba babituwe nga 21 January n'okutuusa olwaleero baatuwaako bitono mu volume 1 naye balina volumes endala mu ze baleeta tebatanaba kutunnyonnyola volumes ziri mmeka. Kati olwaleero bo bennyini bibakalidde ku maaso kubanga bulijjo batuteekako nnyo olukongoolo nti abo balooya ba Besigye be bavuddeko embeera eremesa omusango okugenda maaso, abo bali mu mizannyo tebaagala kkooti ewulire musango gugwe, abo ne batuteekako olukongoolo ne mwami Museveni yennyini ne batayibwa mu sipiika deputy speaker n'abalala bonna eyo mu gavumenti, abo abalooya olwaleero bibakalidde ku matama batuuse wali nga bo bennyini be bagamba nti tebalirede. Mukimanyi nti fayiro eno bagireeta ennaku z'omwezi 29 omwezi ogwokutaano omwaka oguwedde n'okutuusa olwaleero nga bagamba obujulizi buwedde naye n'okutuusa olwaleero obujulizi obwo tebabutuwa. Twebuuza sookera ddala obujulizi bakweka bwaki? Oba nga balina obutambi nga basobola n'obutwala ne babusaasaanya mu social media ne batandika obugabagaba buli wamu, lwaki ffe balooya tebabutuwa? Nti obutambi obuliko amaloboozi ga Dr. Besigye n'abantu be yali agamba nti simanya bagula emmundu, simanya bamonitalinge wa gy'abeera wa gy'asula, simanya bagula drone baagala kutta mwami Yoweri Kaguta Museveni. Obutambi obwo buliko amaloboozi ago bwe bagamba bwe batadde mu biwandiiko, lwaki tebabutuwa n'okutuusa olwaleero? Kati bagambye nti bajja kubutuwa ng'ennaku z'omwezi 3 omwezi ogwokusatu, katubalinde. Naye ekyo kyekiremezza ne hearing ogenda mu maaso nti obutambi baganya okubutuwa. Ate weebuuze nti oba bulijjo babulina, lwaki tebabutuwa? So yembeera eyo gye batutaddemu, naye ffe ekisinga okutunyiga nti bwe bulamu bwa Dr. Kizza Besigye mumulabye agenda ayongera okunafuwa, yegenda anafuwa yeyongera okunafuwa, era tuze tusaba beyiro emirungi mingi, kooti negaana okumuwa beyiro, naye tukyatakula amateeka na buli kimu okulaba nti tufuna orders eziyinza okuba nga ziyambako ku mbeera y'obulamu bwe, naddala okulaba nti abasawo bamuwa obujjanjabi obumala ate nga nekya beyiro tetunnakivaako, okulaba nga ali bweru asobole okuba nga yeerwanako ng'ali bweru ate n'okuba nga yejjanjabisa ng'ali bweru wa kkomera. Sebe byonna tukyabiremeddeko mu mbeera yo. Mwebaleka.